Hey, Eric.
Hey Heather, how you doing? Good.
Good. Hey, while we're waiting, can I call you real quick?
Sure.
Good afternoon. This is Judge Tammy Long Hayward. This is courtroom 304, Clayton County State Court. This is our civil motions calendar. I'm going to call the cases on the calendar, and then we will proceed. So we are recording, and we also are live by YouTube. So there is a record. All right. So first case on the calendar is Monica M. Whitaker versus Kevin E. Bernard.
Hi, good afternoon, Your Honor. My name is Arjun Nair. I'm here on behalf of the defendant, Mr. Bernard.
Okay. All right. Is there anyone here on behalf of Monica Whitaker?
Yes, this is Attorney John Brogdon, plaintiff Monica Whitaker.
All right, Mr. Brogdon.
It's 1:06 p.m. and we are now off the record.
All right, and this is an auto accident case. Tell me what we're here for.
Yes, Your Honor. We're here for a motion. Well, we filed a motion for default judgment due to the defendant filing the answer past the time, and now we're here for the hearing. They filed a motion to open default, and they have not responded within their motion about any reasoning pertaining to why the defendant failed to file an answer. And at this point, we just want the default granted and to move forward.
Mr. Nair?
Yeah, so my records show that the complaint was filed on September 16th, 2024, and then I believe service was on October 8th, 2024. Mr. Bernard did not advise his insurance carrier, State Farm, of the suit, and that's because of he didn't know what to do with it. I don't know, what the, didn't know what to do with it. Ultimately, it looks like the plaintiff himself advised State Farm, and then they sent the case to us, and I filed the answer within 45 days. And we're ready to go. I mean, I don't believe there's been any prejudice to the plaintiff in this case.
All right, so you paid cost.
I believe so. Yes. We sent the check, and it should have been the appropriate amount. I don't have any other correspondence on that, but yes, we sent the check.
Okay, and you met all of the. I mean, Mr. Brogdon, sounds like excusable neglect. Seems like they've met the requirements, and striking the answer or refusing to open default in a case where it seems practically pretty reasonable is sort of the extreme, as opposed to letting the case proceed on its normal course. Is there anything else that the court needs to know?
The only other thing, Your Honor, would be that within their motion, they don't say anything about the reasoning of defendant. So we don't have any information pertaining to that. I understand about the reasoning. The defendant did not file an answer or report to his insurance company. And that's a piece of the inquiry a court should take into account. So I think that should be considered, but I understand.
Okay. Well, Mr. Nair stays in his place. A lot of times people, let me just tell you how many times I have to lecture people about actually reading the summons. That gives you everything you probably should know about how to respond to a complaint. But in this case, because it hasn't been a time that is seemingly unreasonable based on what I have, then the court is inclined to allow for default to be open and for the course of the discovery to continue.
Okay. Thank you, Your Honor.
So, Mr. Nair, I'm going to assume that you have provided the court with an order. If you have not, I would ask that you do so.
Yes, Your Honor. I'll follow up on that. Thank you.
All right. All right. Y'all take care.
Yes, ma'am. Bye-bye.
All right, M&M Countertops LLC versus Tiffany Thomas. Anyone here on behalf of M&M Countertops LLC? Really should be an attorney because they're an LLC. Is there an attorney here representing the company?
Hello, ma'am. Your Honor can
Mr. Mendoza?
yes, ma'am.
All right. Are you related to M&M Countertops?
Yes, I'm the owner.
Okay, so you have a corporation, Mr. Mendoza, and in state court, the rules require that a corporation be represented by an attorney because when you incorporate, even if you're the only person, the reason that they require an attorney is because corporations generally represent the interest of more than just one person. And so for a fiduciary responsibility, you want a neutral party who's going to represent all of the interests of owners or shareholders in a corporation. And so the rules require that an attorney represent you. May I see you, please?
Um,
Yeah, let me see if this will help. Start video.
there you go.
There you are. All right, so you are suing. Is there anyone here on behalf of Tiffany Thomas?
No, I don't have an attorney.
All right, Ms. Thomas. There's an eviction and a counterclaim. I can continue the case, Mr. Mendoza, because both really need to be heard. I don't want to dismiss you just out of hand because you didn't know the rule about having an attorney. I can reset the case for 30 days and give you the opportunity to get an attorney on board, and then we can hear both the claim and the counterclaim.
Yeah, if that's the sooner we can do it, that'd be great. Thank you.
All right, so go ahead. I'll reset for 30 days, Ms. Thomas. You'll get notice also. If you wish to have an attorney represent you also, you are more than able to do that. You're not required to. You can represent your own interest if you choose to. So we're going to go ahead and reset. All right, and Mr. Mendoza, please make sure that you have an attorney to represent the corporation, okay?
Okay, thank you.
All right, thank you. North Star versus 3D&T Transport LLC and Daryl Harris.
Darren Harris. Yes, Your Honor. Good afternoon, Bo Hayes for North Star Division
All right,
of
Mr. Hayes.
People's Bank. The court entered a default judgment on liability back in April of 2024. We have this set for damages.
All right, you have your expert?
We filed a Rule 902 business records affidavit with the motion for default judgment.
What is it you're asking for?
Thank you, Your Honor. Let me go over to that page.
All right, I'm going to call for 3D&T Transport LLC, Daryl Harris, one more time. I don't see them present. All righty. Okay, go ahead, sir.
Yes, well, this was a motor vehicle lease. The truck was leased by North Star. They have not been able to locate the truck, so it has not been picked up. There's not a deficiency balance. It's an entire loss. And the total that my client is seeking is $19,812 is the principal balance per the breakout of the balance owed, including the default fee under the lease. As well as interest in the amount of $9,050.12 because the contract provides for 18% interest, and attorney's fees under 13-111 of 15% of the first $500 and 10% of the balance, which is $2,911.21.
All right, and court costs?
Yeah, we would ask the court to include court costs in that too.
All right, anything else I'm not thinking of?
Don't believe so, Your Honor.
All right, so the court is going to grant $19,812 in principal, $9,050.12 in interest, contractual interest, and $2,911.21 in attorney's fees as permitted by the contract. And sir, if you have not already submitted an order, if you would do so, we'll go ahead and get that signed.
I will get that order submitted to the court right after the hearing here.
All right, thank you so much.
Thank you, Your Honor. That's my only
Judge,
case.
we're trying to make sure the courtroom is open. I'm trying to reach the deputy because I had people waiting to get in the courtroom.
He's online. I'm not sure. Can you call him?
The camera on, and I don't see no one in there. Let me see.
I told him 1 o'clock, so.
So I'm here, Your Honor.
All right, is there anybody in the courtroom, deputy?
No, I go out in the hall and see, but I've been sitting here. I ain't had nobody come to the door.
Okay, check for me. Make sure the door's open.
Yeah, someone called from the clerk's office saying someone was trying to get in and they say the doors was locked. They may have gone to the wrong courtroom.
Okay, no problem. I'll go out in the hall.
All right, check for me. Miss Gutter Parker, how are you? You gotta unmute.
How are you doing?
I'm good. We go back to law school, y'all. Good to see you.
It's been a long time. Yes, Happy New Year.
Happy New Year to you too. You're here on Carter Gibson. Erica Gibson is administrator versus Uganda Levy, Jashawn Cross, and John Doe versus State Farm. Is that correct?
Correct.
All right. So Ms. Gutter Parker is here. Anyone here for Uganda Levy and Jashawn Cross and John Doe?
Yes, Your Honor. Chris Harrison, Downey and Cleveland for Miss Levy.
All right, Mr. Harrison, and State Farm Mutual.
Your Honor, Donna Davis here on behalf of State Farm.
Okay. All right. All right. Let me check and make sure I haven't missed anybody from the earlier cases who are in the courtroom. Deputy, I'm going to call some names. If these people are in the courtroom, have them come up to the computer for me. Kevin Bernard. All right, Mr. Nair was here on behalf of Mr. Bernard. Tiffany Thomas was here on, and Mr. Mendoza were here on the second case. And on the third case, Daryl Harris. Is there a Daryl Harris? Nope. Okay. Then we are good.
Your
So far,
Honor,
so
it's
good.
green in the courtroom.
I'm sorry.
It's green.
Okay, so we haven't gotten to Ms. Green yet, I don't think. All right, so Ms. Gutter Parker, you are here on behalf of the plaintiffs. Tell me what's going on, and we do have a cross claim.
Yes, we filed a motion for default against Jashawn Cross. And so he has not responded. We filed an order and just ask that Your Honor sign the order with regard to the motion for default.
All right. So, Mr. Harrison, if I am correct, you are representing only defendant Levy.
Yes, Your Honor. Correct.
All right. And Ms. Davis, do you have a dog in this fight, or are you sitting this one out?
I do not have a dog in this fight, Your Honor.
All righty. So for the defendant, Jashawn Donnell Cross, was served but did not respond, and you against Mr. Liquidated or unliquidated damages.
Correct, Your Honor.
Unliquidated?
Yes, unliquidated damages.
Okay. Do you have someone that?
And I'm sorry, right now it's just with regard to liability only,
Okay,
Your Honor.
that's fine. All right, so at this time, the court is going to grant the motion for default. Mr. Cross is not represented. He has not appeared. He did not file an answer. So this is solely for defendant Jashawn Donnell Cross. And Ms. Gutter Parker, if you haven't already submitted an order, you can go ahead and submit one to my staff attorney, Ms. Powell.
Thank you, Your Honor. It has been filed. Thank you.
All right, and I will go ahead and get that signed.
Thank you.
There are two more pending motions. There's State Farm's motion to open default, which the plaintiff responded to, and there's also defendant Levy's motion. I'm sorry, I'm missing the proper language, but they're saying that the minor cannot sue on his own behalf.
Okay, so it's my understanding that there's an administrator. So is the minor, is that still an active issue, or is that moved?
Your Honor, we didn't have the administrator paperwork when we filed the motion, but I would say, I think the style is not clear. Right now, it's Carter Gibson individually and a surviving child of Naomi Gibson, deceased. And then separately, you have Erica Gibson, I think it's the grandmother, but Tassie, correct me if I'm wrong,
Correct.
as administrator. So as it's still pled, the minor child, who's obviously not of age, is bringing the wrongful death claim himself, which he cannot do. So if there's an administrator, which it appears that there is, I think we need to amend the style if the court's going to allow that to happen.
Okay, that's fine with me. Y'all come up with the style and then go ahead and we'll do a short little order to amend the style of, and then that would render the motion moot, and we would be good going forward.
Yes, Your Honor. Thank you.
All right. And then for State Farm, you all had a motion to open default on behalf of whom?
Yes, ma'am. We had a motion to open default on behalf of State Farm. When State Farm was served on May 2nd of 2023, they were unable to locate a policy. They had reached out to Ms. Gooder Parker multiple times to retrieve that policy information, and were not able to clarify that issue. Unfortunately, in that time frame, the answer deadline passed, and then a month later, we were able to answer, pay costs, and file this motion to open default. This motion to open default was based on two grounds, both excusable neglect for State Farm's inability to locate this policy due to misnomers, and then also on the proper case grounds, and that has been briefed to the court. At this point in time, State Farm has evaluated this case. It has located policies, and it has paid the available limits of those policies. So this issue
I'm sure there's no
still outstanding.
Opposition. Yeah. Okay, so the court will grant that. That takes care of that.
Perfect. Thank you, Your Honor.
You're welcome. Anything else on behalf of you, the Gibson versus Levy case?
No, Your Honor. Always great to see you.
Good to see you too. We'll get those orders out. Thank you, everyone. I
Your
look
Honor,
forward to seeing. Yes.
I would ask for just brief clarity on whether there would be any discovery period for State Farm now that this motion has been granted.
How much you need?
I would ask for 90 days. I think that would be a nice abbreviated period to be able to conduct discovery.
Any objection? All right, sounds good to me.
Thank you.
All right, let's go ahead and put that in the order.
Thank you, Your Honor.
You're welcome.
Appreciate your efficiency. Good to see you.
I'm trying.
You're doing great. You're doing great.
Ms. Powell is fairly new with me, and she is she's coming in guns blazing. So
I'd like to see it.
I appreciate it. I'm trying to keep up.
Yes, Your Honor. Thank you.
Thank you all.
Thank you.
All right. Bye-bye. All right. Next case on the calendar is Doug Smith versus S&W Plumbing LLC. Berkshire Hathaway was dismissed, if I'm not mistaken. And then CCOM Holdings LLC is represented. Clayton Properties Group is also here. And this is a claim for damages with cross claims. All right. So I have that attorney Hergenrother has a leave from 2/11 to 2/18.
Yes, Your Honor. My name is Erin McGonigal, and I'm here on behalf of S&W Plumbing.
Okay.
And he does have a leave. Yes, ma'am.
All right. So are you willing to go forward in light of his leave?
Yes, ma'am.
In his stead. Okay, great. All righty. So what do we have pending?
Your Honor, this is Heather Miller, and I represent, along with Brianna Glover, represent the CCOM Holdings defendants, who are CCOM, DBA, Chapin Communities, and Clayton Properties.
Yes.
We're here on our motion for summary judgment. It's a two-pronged summary judgment. I think the second prong, the second argument has now been taken care of and will not need to be heard by the court, because S&W Plumbing, who we have a cross claim against and who we had a motion for summary judgment as to that cross claim for the indemnity portion of this case, they accepted the tender this morning.
Okay.
So, so we'll take, if our motion is not granted with regard to our first part of our claim, we'll take care of that later, but we won't need to be heard on that today if Mr. Campbell agrees.
Good afternoon, Judge. My name is Eric Miller. I represent Doug Smith in this case, the plaintiff.
All right, Mr. Miller. All right, so I'll go ahead and hear the portion of the SJ that remains.
Okay, thank you, Your Honor. So this case arises out of some property damage. My client, I'll just call it the CCOM defendants, contracted with Mr. Smith to build a home. My client then hired contractor S&W for the plumbing portion of this. They entered into a master services agreement where the plain language of the contract states that the work to be performed under that agreement was their own work and at their risk exclusively, meaning that plumbing companies risk exclusively. Years went by, and apparently there was alleged by the plaintiff, a faulty nut or piece of this plumbing on the toilet that caused water damage. Thus, this lawsuit ensued. Georgia law is clear, however, that a contractor cannot be liable for the acts of its subcontractor unless there are specific exclusions to that. So we filed our summary judgment based on longstanding Georgia law that a contractor is not liable for its subcontractor's negligent work. And therefore, the burden then shifted to the plaintiff to show that some exclusion applied to that general legal proposition under OCGA 5125. Plaintiff filed a one-page response stating setting forth no evidence through discovery and no case law that would say that this fell within some exception to that rule. So we believe that the Georgia case law is clear, the statute is clear. This does not fall within any of the exceptions. Plaintiff has not shown any evidence that there are any exceptions to the rule that this subcontractor was doing work on its own, liable on its own, and therefore we believe summary judgment should be granted just based upon the clear, plain language of the statute, the plain language of the Georgia case law. And we can talk about that case law if Your Honor would like to hear some of it. But
okay, let me ask a couple of questions. So as the general contractor, they didn't require the plumbers to use a particular type of toilet, a particular nut, a particular method of installing.
That's correct.
They didn't hire any of the subs people.
Correct.
And they didn't have anybody supervising the plumbing sub.
Correct.
Okay. Was there any, did the plumbing sub participate in any design with the general contractor?
No, Your Honor.
Okay.
They're completely apart. And like we said, we control none of their, none of the manner of their work, the method of their work. And there's been no evidence presented by plaintiff or S&W that states otherwise.
All right, Ms. McGonigal.
Yes, ma'am, that's our understanding as well.
Okay. Anyone else have anything on this, on the summary judgment motion?
Yes, ma'am.
Mr. Miller?
Yes, ma'am. So first of all, this is a negligence case. And so most negligence cases have to be decided by jury. Second of all, there is a master agreement between the builder and the sub. And that doesn't really surprise us. I mean, most houses are built by subs in that situation that the builder contracts with the homeowner and then the subs actually do all the work. That's the way it works most of the time. So the fact that there's a master agreement, as we put in our initial response, doesn't really affect us. I mean, we know that subs generally do the work of that is required by them in their tasks. Now, we're getting into some legal stuff now. This is the third and fourth reason.
That's sort of what I do.
I know, Judge. So the first part of that is, while 5124, the statute, does say that independent contractors are not responsible for the acts of the subs, that is the case that 5124 actually works. 5125 has exceptions to that rule. And in fact, the restatement of torts has come out and said the exceptions swallow up the rule. So the exceptions are what's a matter here. Now, there are like 6 exceptions, and there's only one that actually, like, they have to do with the work is dangerous in itself and things like that. That doesn't apply. But what does apply is if a builder has any kind of express agreement with the homeowner to actually do the work, then the legislature has decided that in that situation, the builder is responsible along with the sub for the work that is done. In other words, a builder cannot hide behind the bad acts of the sub and then by the same token, say, well, that was done by the sub. We didn't have anything to do with that. And by the same token, take money from the homeowner and then pay the sub. See, normally what happens is the homeowner strikes a deal with the building contractor for, in this case, plumbing, but they work out everything like roofing and, cabinets and walls, everything goes into that. So they can't, the builder cannot take the homeowner's money per contract or agreement and then say, oh, we didn't screw that up. It was actually the builder. So the legislature under 5125 has decided that plumbers, or in this case, plumber, but any sub can't avoid liability, or builders can't avoid liability by blaming a sub. So it doesn't mean the sub is not responsible. It just means that the sub is going to be responsible along with the builder for any work that is done. If you think about it,
the mere act of how the sub is paid, meaning I'm handing the money to the general, they then pay the sub, versus I'm handing my money to the sub, and the general, I guess, takes whatever the fee is for being the GC. So that's what means now that they're still jointly and severally liable.
That's not Georgia case law, Your Honor.
Yeah, we got rid of joint and several liability back.
That they're both going to be on the hang for the negligence.
If the homeowner had hired the plumber, we wouldn't be here. I mean, that's the way it works.
Okay, so it's not just that they pay them how they pay them. It's just that it's how they choose them.
Well, all right. So here's what happens.
Because let me understand, if I decide I'm going to have a house built, and I hired a GC, conventional wisdom says that I don't really get into the weeds of who they're going to call as far as plumbing. I'm going to trust that my GC, within the parameters of how much I want to spend, what type of materials I want to use, and what the construction plans are. I don't get into the weeds about which company you're going to call to do the work, as long as it's within the parameters of how much money I want to spend.
Correct.
And the ability to make the property look like what I want it to look like. So,
exactly right.
Not jointly and severally, but, I got these two people, these two entities that are responsible for what I want to have done.
Exactly.
And so you're saying that if I choose them, which makes sense, then the privity of contract is between me and the sub, and anything that happens, the sub's liable for.
So the builder is actually responsible. So all the legislature decided by passing 5125 is that the sub, or in this case, the builder, can't avoid liability by saying, oh, we hired this sub and the sub screwed up. So in that situation, we still can hold the homeowner, in this case, can still hold responsible the sub, but the builder is also on the hook. In other words, the legislature decided, I think rightfully, that the builder can't take the homeowner's money and then blame somebody else when it goes bad.
Your Honor, that is just a complete misstatement of Georgia law. And Mr. Miller knows that if there had been a case to support that, he would have placed that in his response brief to our motion for summary judgment. The statute he is correct in that there are ways that a contractor can be liable for the acts of its subcontractor when one of those exceptions 1 through 6 are met. Plaintiff has not come forward with not one piece of evidence to show that one of those exceptions have been met.
Okay, so Mr. Miller, let me ask you. So the first exception is when the work is wrongful in itself, or if done in the ordinary manner would result in a nuisance. So plumbing, installing a toilet, I haven't actively done it myself, but I've seen it done a ton of times. Installing a toilet is not a known nuisance.
No, ma'am.
Okay, so as long as you get the seal right and you get it clamped down right, that's in the ordinary course, it should not cause a problem.
Yes, ma'am. Exception 1 does not apply.
All right. So number 2, if according to the employer's previous knowledge and experience, the work to be done is in its nature dangerous to others, however carefully performed. So that's not an issue here.
No, ma'am.
If the wrongful act is the violation of a duty imposed by express contract upon the employer.
Yes, ma'am.
And you're shaking your head.
That's number 3. That's the one that applies.
And here is why it does not apply.
I didn't mean
Hold on, let me hear from Mr. Miller and I'll let you rebut, Ms. Miller. Go ahead.
What we're saying is exception number 3 applies. And what that means is if the homeowner, in this case, Doug Smith, hires the builder and the builder decides to hire subs, then in that situation, if the sub does something wrong, then the homeowner can hold the builder responsible. In other words, it prevents builders from taking the insured's money, in this case, Doug Smith, and then pointing to the sub that might have screwed up. So that applies here, exception number 3.
The reason why it does not apply is the plain language of the statute, which says the duty imposed by express contract upon the employer. And that is an express contract between the employer and the sub. It has nothing to do with the homeowner. This is a statute that is specifically speaking to sub and contractor. And so a contract between the homeowner and the contractor and the homeowner, that is not what this statute is even addressing or talking about. So that while that's clever arguing by Mr. Miller, that is not what the statute says. And there is no case law that would support that says that number 3 means something between the homeowner and a contractor. This statute is about exceptions to the rule that that a contractor is responsible for a sub, nothing to do with the homeowner here. And so if there were a case that was supportive of that clever argument, Mr. Miller certainly would have provided it to this court, and he did not do so. So this statute has nothing to do with the homeowner. This is a contract, an express contract between the contractor and the sub, in this case, S&W, which we've provided to the court, which specifically states that S&W has their own responsibility to the homeowner, which is why, Your Honor, that S&W accepted our tender in this case and will move forward and be handling anything that a jury may find is liable, any damage that a jury may find liable. Your Honor, if that were the case, if Mr. Miller's argument or plaintiff's argument were correct, then there would not be any 1 through 6 because every single contract would be a contract that would allow a contractor to be liable for any of the acts of its subs. And that's
because presumably every homeowner has a contract with the general contractor that says you're responsible for ensuring the work is done, including hiring subcontractors to do the work.
That's right. And speaking of what legislative intent was, the legislation in Georgia intended, and the legislature intended, that every contractor that goes out there and decides to build a bunch of houses and hire a bunch of subcontractors, that's the purpose of this statute, is to say you are not always liable for the negligence or alleged negligence of the contractors that you go out and hire. If we didn't have this exception, every single contractor would be liable for every single act that happens on a site that they are not present on. And that's just simply not Georgia law. So, Your Honor, I think the statute is clear. There's been no case law or evidence provided. When we go back to just strict summary judgment law in Georgia, plaintiff has come forward with nothing that shifts after the burden was shifted to show that number 3 exception applies in this case. No piece of evidence, no piece of case law. And so, therefore, we believe plain language of the statute applies and that summary judgment should be granted.
All right, Mr. Miller, I got one more question and then you can continue. So, my understanding is that the damage is alleged to have been caused by, was it a faulty nut or was it misapplied? Like, was there a flange or something that didn't get screwed down correctly? Or was it a faulty product that when screwed in correctly didn't work?
So I think I understand. So with the engineers, I don't get involved in that, but the engineers had a meeting and they looked at the evidence and decided that it was an installation problem. It wasn't, in other words, it wasn't a product problem. Okay. So what I was saying was, Ms. Miller, there's no relation, by the way. We're not related. So I know it seems like Ms. Miller is making my argument for me. I mean, there is a contract between her client and S&W. I mean, we know that for a fact. And if Ms. Miller is correct that there is a contract, that it applies to contracts between the builder and the sub, then we have that. And that's been produced by Ms. Miller. So I don't think she's actually looking at it right, but if we take it as given that that is the case, then there is a contract that has been filed. The last thing I would say is the first thing I said, and that is this is a negligence case, and the jury has to figure this out. I mean, that's the answer here. And
yeah, but before the jury can figure out negligence, they have to figure out that there's an actual duty owed, and that's kind of a legal conclusion. If the contract doesn't impose a duty on the subcontractor or the general contractor, if we can look at the plain language of the contract and there's no duty owed that was violated, then we don't get to the negligence part for that particular defendant because there's no duty. No duty was breached.
And through Your Honor, the plain language of the contract between S&W and CCOM defendants clearly states that their work is their own work, that they will be responsible for their own work, that they have a duty to indemnify us for any claim that comes out of their work. It can't be more clear than that. So there is no contractual duty between S&W and CCOM defendants that would impose any type of subcontractor or contractor liability for subcontractors. That's the plain contractual language. And Your Honor is correct that is a legal question that is up to the court, that can be left up to the court to decide as a matter of law, not as a matter of jury determination. So
and trust me, Mr. Miller, I am more than willing to let the jury decide as many things as possible. I don't impose myself unless it is absolutely necessary or it is a duty that I have. And so I will look, like I've heard your argument. I will look at this again. But this is kind of one of those things that are kind of hard to overcome when you are dealing with. There's a lot of case law on this with respect to the master sub or master servant relationship, and so there has to be something pretty out of the ordinary for you to overcome that and make it a part of the exclusion.
Your Honor, so I do understand what Your Honor is saying, and I understand you have to look at it. But Ms. Miller has set up the contract. It's kind of disingenuous to say that on one hand, they agree to indemnify and agree to do all these things, but under the different breath say, but there's no duty on S&W to do this work. I mean, so that doesn't make any sense. I mean, if there is a contract, and frankly, in my 30 some odd years, I haven't really seen contracts like this between a general and a sub. But if there is a contract between the general and the sub, as Ms. Miller has included in her brief, then I think that contract is full and complete. And there's definitely a duty for S&W to perform the plumbing work in a good and workmanlike manner. And that is in the contract. I mean, there's no question about that.
I think maybe Mr. Miller or plaintiff is misunderstanding number.
Yeah, I'm a little confused because I thought that the duty that we're talking about is the duty owed by CCOM and Clayton Properties to Mr. Smith versus S&W Plumbing. If S&W decides that they're willing to indemnify the general contractor in order to get the work and to get paid, then that's the agreement between the two of them. But indemnification itself doesn't indicate a duty or a responsibility. It just means that when everybody gets sued, we've got you. We're gonna take on the responsibility of the work that we did, even though they've sued everybody.
Right.
That's my understanding of the indemnification provision.
That is correct.
Now we are talking about an agreement between the homeowner and the general. I was simply arguing the way Ms. Miller was arguing, and that is by saying that there is an agreement or contract between the general and the sub.
Okay.
So she was arguing that, and I was just going with that. I mean,
okay.
She is taking the position that there is an agreement between the general and the sub, which there is. I don't think 5125 says that, but if we are going to look at it as an agreement between the general contractor, in this case the builder, CCM, and the sub, in this case S&W Plumbing, then fine, I'll go with that if that's what, I mean, it's her motion. If she is...
Well, I'm going to look at both contracts because I'm trying to find this duty, which is what I'm kind of responsible to do, is to find the duty that's owed to Mr. Smith and to find out who owes that duty, whether it's CCOM and Clayton Properties, or whether it's S&W, or whether both owe a duty which was breached. And so that is what this whole thing turns on, and we'll look at it. But just to go a step further, under 51.2-5, if the wrongful act is the violation of a duty imposed by a statute, that's not applicable here. If the employer retains the right to direct or control the time and manner of executing the work, or interferes and assumes control based on what has been represented so far, that's not the issue here. And if the contractor ratifies the unauthorized wrong of the independent contractor, that's not in play here. So this totally turns on number 3 as the exclusion that Mr. Miller is asserting on behalf of the plaintiff, and a duty that may or may not have been existed from the general contractor to the homeowner.
Yes,
Am I correct? Do I have it right?
That's the way I look at it. Miller has argued something different. But I do believe that is the way we ought to be looking at this. Whether there's any kind of duty between the homeowner and CCM or CCCM, whatever they're called.
Really quickly in response, again, it takes us where you're talking in circles, I'm afraid. But the statute itself says, if the wrongful act is the violation of a duty imposed by express contract upon the employer, that meaning the contract, my client, an express duty implied by contract with the employer means the S&W contract with the CCOM contract or Clayton Properties contract. Those are the two contracts we're talking about, because what that's saying is if their contract has said, we're going to...
If CCOM says, hey, if something happens, I'm going to take it upon myself to take on the responsibility for that. I get that, but I'm trying to figure out where Mr. Miller's argument is, where his client is in direct privity of contract, so that any plumbing work done under the GC CCOM done by S&W, now he can come directly at CCOM as opposed to S&W.
That's right. And there's been no case law. There's been no contract that plaintiff has provided. There's been no case law that plaintiff has provided to support such an argument. And there's no issue of fact that plaintiff has come forward to somehow insert a plaintiff into a privity of contract between a contractor and a subcontractor.
I got you.
To go against all of Georgia law. So
that is what I understand, but like Mr. Miller is making somewhat of a novelish argument. I'm gonna look at it, but I'm gonna follow what the law says. I do believe it is my duty to determine, based on a determination of the law that applies, whether there's a duty owed to plaintiff in this case.
Thank you, Your Honor.
All right. Anything else?
Not for myself.
All right. We'll get that. Did we have another issue, Ms. McGonigal?
No, Your Honor, that's all. Thank you so much.
No problem. All right. Well, we get this knocked out. We'll get an order out to you, and then we will see where we are with respect to when we can start lining our ducks up in a row for a trial. All right.
Yes, ma'am.
Thanks, everyone.
Right. Thank you.
Thanks, y'all. Have a good day.
You too.
Bye-bye.
And Calvary Portfolio Services versus LaSonia Denise Bird.
Good afternoon, Your Honor. Sarah Robin for the plaintiff.
Hi, Ms. Robin.
Hi. We're here for, oh, go ahead. I'm sorry.
No, I was just saying, how are you doing? It's been a minute.
I'm good. How are you doing?
I'm good. Is Ms. Bird in the courtroom? All right. So last call for LaSonia Denise Bird. All right, Ms. Robin, go ahead. Tell me what you got.
Your Honor, we are here, unfortunately, for the second time because we have not been able to perfect service of our petition to renew a judgment on the defendant. I would like to ask for another continuance, but I do understand that it has been outstanding for a good 5 to 6 months.
Yeah, why don't we dismiss until you're able to, I guess, locate?
Yes, ma'am. Well, the sheriff doesn't know. We did contact the sheriff to find out why they haven't been able to serve her yet, and they were supposed to get back with us on that. So we will just tell them we'll pull it.
Okay. All righty.
All right.
Some people are better at going to ground than others.
Yes, that is true.
No problem. But it's a pleasure seeing you again, ma'am.
You too. Thank you.
All right. Take care.
Your Honor, Judge, just to be clear, are we dismissing for one of prosecution, or is plaintiff filing an order dismissing without prejudice?
Plaintiff can file an order if they want to.
Okay.
It's up to
We
Ms.
can
Robin.
do that, Your Honor.
Oh, I'm sorry.
We can withdraw our petition.
All right. That works.
All right. Thank you.
And the last one that I have is Celia Green versus Royal Palms Inn. And I have that both are pro se, but I see Mr. Green is here.
Yeah,
Mr.
Judge,
Green,
I'm here on behalf of the entity, not the petitioner. My client is Mr. Patel and
hold on a second. I'm missing
Partha,
something. You said you're here on behalf of who?
Partha Sai LLC and the Royal Palms.
Okay,
Someone's in the courtroom.
Yeah, someone's in the courtroom, but something's going on with your audio because I'm not hearing. So are you here on behalf of Royal Palms Inn?
Correct.
Okay, and so and I take it this is a Pathos from on appeal from the magistrate court? Dispossessory?
Correct, Judge.
Okay. All right. And is that Miss Green who's in the courtroom?
Yes, ma'am.
All right. Come on up, Miss Green, to the computer. All right, so Ms. Green, it is my understanding that the defendant Royal Palms has gotten a judgment against you in magistrate court, and you are here because you are appealing that judgment. Is that correct?
Yes, Your Honor.
All right, one second. Let me
May I say thank you for taking the time to hear this case. It's very important to me, and I'm honored to be among your presence this afternoon.
No problem, Ms. Green. It's kind of what I do. So let's see what we can do. Let me find the bench brief so I can go back to the procedural history on this. There we go.
Judge, can you take just a moment to meet me in a breakout room?
Yeah, hold on a second. One second, Miss Green, Mr. Green. I'll be right back.
Thank you.
You can leave it there. You can have a seat till she come back, so you ain't got to keep standing there. Okay.
All right, Mr. Green, I have a question. So Royal Palms Inn, is this like an extended stay or is this an apartment complex? Mr. Green, can you hear me? Can anybody hear me?
Okay.
Mr. Daniel Green?
This is Cecilia.
Yes,
No,
my client, Mr.
Mr. Green, your audio is horrible.
Are you there? I know.
Boy, he got slow internet and a cheap computer.
Mike Patel because they need to mute. I can hear feedback.
Yeah, Mr. Green,
This is Pastor Cecilia Green.
Mr. Daniel Green, Mr. Patel, Mr. Patel, I need to see you. And I need y'all to,
No, Judge.
okay, that's better, Mr. Green, much better. I can hear you much better. So you can get rid of the one that's not working. Yeah, that's better.
Just look over the brief
All
again.
right.
Just give me 1 second. So Judge, this is my client is on. His name's Mike Patel. Mr. Patel, can you hear me?
Yes, I can hear you.
Okay, could you answer the judge's question for me?
All right, Mr. Patel, can I see you?
I don't know. It's all.
Hold on. Yeah, are you on your phone?
No, I'm on the computer.
Don't see a video option. All right, so Mr. Green, is this an extended stay or is it an apartment complex?
No, this is not extended stay or apartment complex. This is a hotel. Daily rented
Hotel.
room. Right.
All right, and how long is the longest rental period?
We don't have a time frame. Tenant can stay as long as they pay the rent.
Okay, and how do they pay? Like, do they pay daily, weekly?
Only daily. No weekly, no monthly. We rent only on daily basis.
Okay. All right. 1 second. Miss Powell, print out the magistrate court judgment for me, please. Okay, so Miss Green, when did you start staying at the Royal Palms Inn?
Unfortunately, it was right during the COVID area when I and my son was, I have 2 sons. I and my youngest son was put in a precarious position as to where we were homeless and didn't have anywhere to go. And some of my my church brothers and sisters helped me to find a place. It wasn't every day at the start. It was whenever we could afford it. We did sleep in a lot of people's houses that we didn't know. And unfortunately, we had to stay in the car for one night.
Okay, how old is your son?
My youngest son is 27, and he basically paid 90% of whatever he got came from my son's paycheck. Your Honor, I would like to add something else if I could pertaining to this.
Sure.
It's so obvious that we have been dealt a really bad hand. And the reason why I'm saying that is because when Mr. Patel came over here on October the 31st and filed this hideous, I don't know what you want to call it, against us, he just didn't start out right. He didn't tell the truth about why he came over here. And I think it's really sad. If you're going to bring something like this against somebody, don't just tell your part of it, tell it all. And he left out a whole lot the day that he came over here on October the 31st and did this. And for me, it was embarrassing. It was embarrassing, to be honest with you. I'm not being here.
Miss Green,
Yes.
hold on a second, because this is a little bit, I know people are struggling, but you have 2 grown-ups, your son is working, but y'all have been in a hotel, not an extended stay, but just a daily hotel since COVID. That would have been like 2020, 2021, and y'all haven't moved forward from there. So let's talk about kind of the limits of how long you can stay in a hotel and what issues occurred such that an eviction was issued at the lower level. Okay.
This is why we were there, because we had actually been in a homeless state. It's
I got that.
Not something I'm proud of, but we were seeking shelter wherever we could find shelter. And like I said, we stayed in a lot of people's houses that we didn't even know, between Rockdale County and Henry County and Clayton County. And so we were just looking for something, because I could not work and I only had a SSI income, which was not very much. And my son had a full-time job. And so he was able to carry the load while I was in this position of looking for somewhere to go. Now, we did apply in a lot of apartments in the vicinity, but because I didn't have a good income, along with my son's income, we were denied. That was 3 apartment buildings, I guess in the vicinity over there. And we tried and we were actually denied because of my income situation.
Okay.
I want to elaborate on why he came here, Your Honor. He came here
Your Honor,
about.
I'm going to object to this, just going into, if I may.
Hold on, Mr. Green, because I'm trying to get the procedural history. I'm waiting for Mr. I'm looking, I understand that the dispossessory was initiated. There was an answer filed, judgment was granted, the judgment was appealed, and costs were paid. The issue that I have is that I don't have the printout for some reason.
Oh, I got you. I understand. I just
That's
thought,
what I'm looking at.
right. So when she started testifying about why my client came to file, I just want to object. Thank you.
Yeah, Mr. Green, Miss Green, hold on just a second, because I need to know what happened below before we can move forward up here. That's it? Okay. All right, Miss, oh, thank you. Maybe it's in this stat. Maybe I mixed it up. Okay, so what was the basis of Mr. Patel filing for eviction? Was it non-payment?
Correct.
Okay.
I'm sorry, Judge. I just sent you a message. I was looking in the wrong place. I do have that.
Thank you. Because I got the other stuff, but this is not helping me understand what happened below.
Your Honor, we were paying until my son's job was taken overnight, and we were paying really good until Mr. Patel scammed my son out of almost $4,000 using aliases called Cash App Taylor Sugar Mama.
Okay. Hold on.
That's how this came out.
Hold on, Miss Green. Hold on.
Just tell it all.
Miss Green, hold on. I need to know what happened below before I can move forward with this, okay?
Thank you, Your Honor.
All right. So Mr. Green, what is the amount of the non-payment?
Through today's date, Judge?
Yeah, that's fine.
I'm showing a balance of $9,653.05.
Your Honor, that's correct.
Hold on, Miss Green. Hold on. I'm gonna give you the opportunity to tell me everything you need to tell me. I just need to know how much is charged, how much they're asking for, what the magistrate court knew. Okay, what is the daily rate?
Your Honor, the daily rate is $69.95.
Okay, and how many days overdue is she?
Oh, a lot, Your Honor. This dates back. And Mr. Patel, do you happen to know the last day that you received a payment?
Yes.
It might be back in, was it February 2021?
When did she start paying, you mean?
When was the last day you received a payment?
That was in October 2024, October 2025.
Come in.
Okay.
For September's rent.
Okay. Thank you.
Okay, because what he's asking for on October 31st of 2024 was $2,308.30 for possession of the premises. And then it does list $69.95. So since October of 31st of 2024, we've gotten $6,000 more dollars.
Yeah, Judge, because it's $69.95 a day, which equates to approximately $2,168.45 a month. So I'm not great at math, Judge, but
okay,
that's about $6,500 already added to what she already knew. So that's how we got to around the 9,000.
Okay, all right. Now, Ms. Green, tell me what your appeal is based on, because the court granted possession and judgment against you. What is your appeal based on? Oh, before you start, let me tell you, there's only certain things that I can consider based on the law. But one of the things that a lot of people who are in a tenant position don't understand is that if you are in possession of the property, meaning if you are still living in the property, you have to pay the rent. Hardship is not an excuse. I don't have the money is not an excuse. You have to pay the rent. If you cannot pay the rent, then they're entitled to that. Even if there are things that they need to fix or repair, you still have to pay the rent. You can ask for a deduction or an offset, but you still have to pay the rent. So as long as you're in the property, the landlord is entitled, under Georgia law, they're entitled to have the rent paid. So now tell me what's going on that you now owe $9,653.05.
Your Honor, when I went in on a Friday, 1/1/1/24, that's 11-1-24, to pay what I could pay based on my son's part-time salary. These are the words that I heard, and I'm quoting: "The process have already begun. I can no longer take any payments from you. I have filed a petition against you." Your Honor.
That is correct. Under the law, Ms. Green,
Yes.
Green, he filed on October 31st. Under the law, he cannot take any money after he has filed for eviction because that would invalidate the eviction. So he is legally correct. On November 1st of 2024, he could not accept any money if he still wants possession of the property and he wants to come before the court. So that is correct.
Okay, can I proceed, Your Honor?
Sure.
So when I went in, I asked him to take whatever we could, regardless of what he had already done. And his thing was, I cannot accept any money anymore.
And he's correct.
Well, what do you expect me to do? He turned me down. He did not accept anything from us. I wasn't gonna go over there every day and
no, ma'am. At that point, Ms. Green, you have an option. You have the option to leave, or to pay the entire amount. If he won't take the amount that's owed, then you have the option to leave, but he's under no legal obligation to take less than what he is owed. If he says that it's $69 a day and you don't pay $69 a day, and I get it, your son has a part-time job and you're on SSI, but if you don't pay $69 a day, he can file for an eviction and the court can hear it and they can rule on it. You haven't given me a legal basis for why you should still be in this man's property.
Your Honor.
No, yes, ma'am.
He has done committed so many crimes against.
I'm gonna
Then
object
that's,
to this, Judge.
Mr. Green, you can object all you want. Miss Green, if it is a crime, if there's something criminal that happened, you need to march down to the police station and file a police report or take out a warrant. If the police are not willing to pursue it, the matter criminally, you have the right as a citizen to attend a warrant hearing, and have a judge determine whether you as a private citizen can bring a criminal warrant. But that has nothing to do with evictions.
That is exactly what I did on the morning of 11/1. I went to the Clayton County Police Department.
Okay, that's not anything criminal. That's not going to be relevant.
I know, but I'm just telling you, you just mentioned, I think I heard that right. Correct me if I'm wrong, that I should have went down and filed a report against.
No, I said that is something you can do. I'm not telling you to do it or not do it.
I did it.
What I'm saying to you is you have not given me yet a legal reason why Mr. Patel is not entitled to have his property and his judgment.
Your Honor, he wouldn't take any money, and I didn't know.
Ms. Green, I have told you before, he's not required under the law. It would be wrong for him to take money after he files. He filed on October 31st. The very next day, he cannot take money.
So what am I supposed to do when
Leave.
I have the money, ma'am?
You don't have all of the money. Do you have $9,653?
The day that I went in to pay him, I had got some help from other people, and he said he wouldn't take it.
Okay,
and now
because
that he wouldn't take it, what am I supposed to do? It accumulated because he would not take anything.
Miss Green, Miss Green, just let me be honest with you, ma'am. What he really wants is you out. He wants you out.
But you
He's
know what's
entitled
really,
to
you know
that.
what's really sad? He committed all these crimes against us, and now he wants
I'm gonna object to that, Judge.
And that's fine, but that's a
it's not
separate
fine. It's
thing.
wrong.
That's not something that we can handle here. You're not going to address the crimes by staying in his property.
I have already addressed the crimes. I went to.
Okay, then staying in his property is not going to address the crimes. I need you, I'm going to give you one more opportunity to give me any legal reason why I should not affirm the decision of the magistrate court.
Because I have nowhere to go. This man.
Okay, that's not a legal reason.
Okay, well, I'm gonna say it like this. What he did to us, what he has put us through is criminal. And it's a sad day when it seems like crimes are okay for some people and not all right for others. He has been eavesdropping on all of my phone conversations for 4 years.
I'm gonna object to this.
I don't even have peace anymore on my phone because
Miss Green, let me tell you, ma'am, the option is to leave. He controls the building. I can't
where
say
do you
whether
go when you don't have nowhere to go? Where do you
I'm
go?
not sure, Miss Green, and it breaks my heart, but let me just tell you, there are people in tough situations on both sides. If you think about it, you're saying, let me stay here because I don't have any place to go. But what you're doing is denying Mr. Patel money that should be going into his business or to his family because you're saying, I'm going to just stay in. No, listen to me.
What about what he's scamming from us, ma'am?
Listen to me. You're saying, I deserve to stay here because I don't have any place to go, but you're denying the fact that he bought this business to make money and to support himself and his family. And you're denying him that money because you don't have any place to go. That's not it. You are responsible for yourself. Your grown son is responsible for himself. You are not Mr. Patel's responsibility. You are not. And as heartbroken as I am that you are in the situation that you're in, that is not Mr. Patel's responsibility. If you believe he's done something wrong or criminal, you have avenues for that. You can sue civilly, you can go and pursue criminal matters, but this is not the way you address that. So at this time, because you have not given me anything that shows you have a legal right to possess the property, at this time, the court is going to grant Mr. Patel the $9,653.05 of the judgment that he obtained from magistrate court. I'm going to affirm that judgment, and I'm also going to give him a right of possession, a writ of possession for 7 days from today. Okay, so you'll have 7 days to vacate the property.
He scammed us out of money, and that's one of the reasons why we couldn't.
Ms. Green, unmute, officer. Let me hear her. Ms. Green, I'm sorry for the situation you are in, but ma'am, that's not Mr. Patel's responsibility.
Yes,
And if he's, and if he,
us, ma'am,
but then that is,
us.
then you go to the police and pursue a criminal action.
I've
But you
done
don't
that.
stay in
I've
his
done that.
property.
I have a case number 240.
Okay, that's fine.
6962.
Then
I've
you
done
do
that. Yes.
Okay, but that doesn't mean you get to stay in his property.
Ma'am, we have been taking so much from this man. It seems like he's getting away with all these crimes and nobody seems to care about what it has impacted our household income and why we couldn't pay to stay over there because he took so much from us from the get-go. He's done this in the broad daylight, ma'am. I'm not lying to you.
I'm not saying that you are, Ms. Green. What I'm saying to you is in the context of an eviction, those are not things I can consider. What I can consider is you have not given me a legal reason for you to stay in the property.
He took from us and we couldn't pay him anymore.
Okay, so unmute, please. I know she's talking, but that's okay. So, Ms. Green, unfortunately, the court is going to have to affirm the decision of the magistrate court. I'm going to issue the writ of possession. You'll have 7 days to vacate. If you are not out in 7 days, then the sheriff will be able to execute the writ.
Man, Ms. Green, you have to relax. You gotta relax. Jesus. You gotta relax. You gotta relax. Jesus. Jesus.
All right, Mr. Green, do you have an order?
Your Honor, I will get an order to, who would you like me to email the proposed order?
Ms. Powell.
Yes, Judge. And then Judge, if I may, I don't know if you want me to wait, but I need to address another case with you. I think I made a big grave mistake. I thought this case was on this calendar and it looks like it might have been on your 11 o'clock calendar.
Yeah, probably.
Yeah.
Which calendar is that?
Judge, it was Velocity Investments versus
Oh,
Charmaine Age. I thought it was, I put it with my files today. I've been going
Ms. Payne, she was here.
Okay, I've been going through chemotherapy treatments, Judge, and I had a recent one last week, and I was putting all my files together, and I put this one behind that one.
Okay, well, you can move the court for reconsideration of its order.
Did you already issue that one, Judge?
I did.
Okay, I'll get that filed.
All righty, and I'm hoping and praying.
Ms. Powell, can you put your email in the chat for me, please?
Yes, Ms. Powell. Ms. Powell, if you'll chat your email to Mr. Green. All right. So,
once I receive that email, Judge, may we be excused?
certainly, Ms. Powell.
Thank you.
I just added it to you directly, Mr. Green.
I got it. Thank you.
All right, and I hope everything goes well for you, Mr. Green.
Thank you, Judge. Good to see you.
All right, good to see you too. All righty, thank you all. This concludes the calendar. The courtroom is down. Thank you, deputies.
Thank you.